The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today on a hearing on foreign abuse of U.S. courts. I want to include that this is the title, but not by any means the limitation. And there are a multitude of bills which have been made available to everyone here that we believe are open and available for discussion. So we have a distinguished panel, and I recognize that you're able to go into areas beyond any one piece of legislation. I'll now recognize myself for that opening statement. Again, I want to thank the witnesses and make it clear that the Chinese Communist Party is waging what they call legal warfare using the U.S. courts. Although this is not new, the previous administration elevated it by covering repeatedly a number of the areas in which the CCP has been, in fact, using our system against us. This is over and above the 10,000 attacks a day that occur on the internet. This is over and above their spying. This is over and above the abuses that occur on companies in China. This is, in fact, using our patent system, our trademark system, and our courts to their advantage. We take this seriously, that we will not be abused any longer. Legislation and rule changes by the administration need to happen and happen now. Let's make it clear. There are legal actions that the Chinese businessmen and others do, and we want to make sure they're protected, just as we want to make sure that American companies, European companies, and individuals all over the world have access to our courts, to our patent and trademark system, and to our economy. In fact, some of our own laws have made it easier for the Chinese to take advantage of us. Our courts are the backbone of our Constitution, and we will protect it. Legislation that sanctions the PRC alone cannot be enough. We also have to strengthen the system itself from this type of activity. One of them is, in fact, open and transparent disclosure of who is truly behind a litigant. That includes third-party funding of litigation. It also includes, and should include, a thorough recognition that often there are a series of shell companies, even U.S. Subsidiaries that, in fact, have little to do with anything except covering their true source. All of that is not new. We see it in criminal operations, in human trafficking, in drug smuggling, in commercial fraud, and that is not limited to any one country. But the fact that it's backed by a powerful country who is using and weaponizing this is particularly disturbing. As we all are aware, often we are just a few weeks, few months, or maybe a few hours in new technology ahead of China compromising it and using it. That includes a look-alike of the F-13. That includes a duplicate of the CERN Super Collider new version. That one will be out before ours is built here in the United States. So we're not going to be able to fix it all here today, and it's not all within our jurisdiction. What is within our jurisdiction is to look at and to make available greater transparency, to empower our judges to order that transparency, and in fact to make it clear that a case should not go forward if, as is constitutional, a person accused of anything criminally is entitled to be faced by their accusers, their true accusers, which would include those who have people step forward. That is our law. But in civil matters, that often is a one-way street. Defendants under Rule 26 have to disclose if they are insured, have to disclose, quite frankly, their own financial condition, and even the financial condition of their principals. That is not always the case in the case of the plaintiff, and we need to have that. In preparation for this hearing, I have met with a great many companies and law firms who use third-party litigation funding or who partner with other companies. None of them object to, in fact, the transparency of disclosing that. Many of them have cautioned that the discretion by the judge as to admissibility to the jury is a different story. And I want to make that clear because it is not the intention of this chair or of any legislation I have yet seen to interfere with a judge's decision on admissibility. But when it comes to the right to know, whether in camera or otherwise, this information is critical in making the decision about protective orders and the conduct of the case. The subcommittee has broad jurisdiction as to the courts, but we want to use it wisely. And in this case, recognizing that transparency is one of the most important tools that we have, we want to make sure that it is brought to the attention of everyone. As I said earlier, this hearing does include a number of other pieces of legislation that I believe our panel is able to answer, and we appreciate your indulgence when those questions are asked.